Welcome to the next video for my video lecture series for economic analysis of the law here at Rutgers University in Camden. And this video is just an overview of what's going to occur in week 11. And in week 11, chapter 10 is covered, and it is titled An Economic Theory of the Legal Process. And there are four major components of this chapter that are important for students to understand. Looking at lawyers in the litigation process is particularly important. Realize that the textbook and some of the mathematical exercises that occur in the chapter try to illustrate the rationality of the decision to sue or to defend, and also the rationality of the choice between suit and settlement. So make sure you're comfortable with that. The text in itself, it seems to be fairly self-explanatory, but make sure you feel comfortable with that process. It can be a little bit challenging, in particular if you weren't comfortable with the section on game theory that we started with at the beginning of the course. Also, some interesting topics come up related to this, particularly the role of a lawyer in the decision-making process, whether or not to sue or settle, etc. Specifically, a question about whether the relative costs and benefits of a suit and settlement are fully evident to the private parties involved. Do they need the experience of a lawyer to recognize the various costs and benefits? And also, if parties hire attorneys to represent their legal interests, does that not raise a principal agent problem like we dealt with in the agency game that we did in Chapter 8. So make sure you realize that some of these questions that come up relative to the efficiency of hiring a lawyer. Also, there's a little bit of a discussion on the effect of lawyers on societal growth or economic growth. And the effect of this in the legal process can be extended to a discussion of the effect lawyers have on society as a whole. Recently, several articles have appeared on the topic with opposing views clearly articulated, and some empirical work reported in an effort to support the opposing views. So make sure you realize that there are two schools of thought in this, that the lawyers, etc., the services they provide retard economic growth, and others argue that that stimulates economic growth. And there's literature on both sides supporting those two arguments. Also, the chapter talks a little bit about frivolous lawsuits, and also realize that there's this notion of frivolity, or the notion of quote-unquote the negative expected value suit, one where the plaintiff has reason to know that the probability of winning is so low and the cost of proceeding so high that there is a net loss from proceeding to trial. Also realize this, that it's possible to do an analysis of the problem of the plaintiffs who proceed without adequately investigating the merits of his or her claims, and proposes a policy for dealing with that situation. So make sure you realize this notion of whether or not there are frivolous lawsuits, why it might make economic sense for individuals to engage in a frivolous lawsuit, and also the fact that the textbook deals with some policies for dealing with that specific situation. And finally, the chapter concludes with the efficiency of the common law process. And most of the claims of the law and economics literature is that the common law process generates efficient legal commands. As the textbook shows, the novelty of that claim lies in the contention that the behavior of private parties, not of judges, lawyers, legislators, or others, generate these efficient laws. To paraphrase Adam Smith, the claim holds that private parties are led as if by an invisible hand to litigate inefficient law and not to litigate efficient law. The textbook and the literature speak of the common law process here in the text, but what is really meant is private adjudication. The broader term is one that should be borne in mind in the discussion of this material, because the forces that the literature identifies as pushing private law towards efficiency would seem to apply to both the civil law and common law systems.